And I'm going to go to our Executive Director, Ms. Baker, for the public disclaimer and roll call.
Notice of the November meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since November 3rd, 2022. Additionally, this month's agenda has been posted on the website since Friday, December 1st, 2023. Individuals who wish to make a public comment on an item listed or Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for others. I will now call the roll. Chair Diaz,
Present.
Vice Chair Ferris, Commissioner Moffitt, Commissioner Begley, Commissioner Torbett, Commissioner Gwynn,
Here.
Commissioner Smith,
Here.
Commissioner Tucker, Commissioner Gahn.
Here.
Thank you.
By my count, we have a quorum.
Yes, sir.
Okay, I'll also state for the record that Commissioners Torbett and Ferris will be joining us shortly. They were delayed because of traffic and parking, so they're making their way. I'll now turn to Commissioner Smith for our prayer and pledge.
Please bow. Dear Lord, thank you so much for this day that we can come together as leaders of our industry. Thank you for the guidance you give us. Give us wisdom and knowledge and compassion as we have today's meeting. We ask that you watch over us as we travel home and continue, Lord, to watch over those in harm's way. In your name we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic.
So now we go to the approval of the agenda. Is there any amendments or questions? Hearing none, the chair will entertain a motion. I have a motion by Commissioner Smith, seconded by Commissioner Gahn to approve the agenda. All those in favor?
Aye.
Any opposed? Hearing none, that motion passes unanimously. Approval of the minutes. Any changes? Hearing none, chair will entertain a motion. I have a motion by Commissioner Smith, seconded by Commissioner Moffitt to approve the minutes of last month's meeting, November 23. All those in favor? Any opposed? Hearing none, that motion passes unanimously. Now we can go to the public comment period. Is there any member of the public that has comments? Hearing none, we will now move to our informal appearances. Ms. Baker, are our candidates present virtually?
Yes, sir.
Yeah, are they, and their principal brokers, I assume, are with them?
Yes.
Please tell us about candidate A.
Today we have candidate A, Randall Price, with principal broker John C. Jones. He is before us today due to a felony unlawful possession of a controlled and dangerous substance with an intent to distribute and acquire proceeds from drug activity. Mr. Price's statement and letters of recommendation can be found on your iPads.
Okay, so for the candidates appearing before us today, just for your information, each candidate will be given time to explain to the commission the circumstances that caused them to appear before us today, and then their principal broker will be given time to speak as well. Commissioners will then be able to ask questions of either the candidate or the broker, and then we will vote. If there are no questions about that process, we'll go to Mr. Price, and please tell us the circumstances that bring us before you today.
I was involved in marijuana, basically selling marijuana at the time out of Colorado, and I was bringing it back, and I got caught, obviously, and I just made, a bad decision about a way to go about making money in a business, and it was just a dark period of my life that I wish that I could take back, but I can't. So I just got to kind of live with it and own it, and hopefully one day move past it.
Any commissioners have questions for Mr. Price? Hearing none. Mr. Jones, please tell us why you would like Mr. Price to be part of your firm.
I was under the assumption your principal broker was present. Is your principal broker present?
I am not sure. I haven't spoke with them this morning or anything like that.
If you would like to text them, we can review candidate B's and come back to you, but your principal broker must be present. I was under the assumption that that person was, so I do apologize.
I'm sorry. Yes, I will try to get a hold of them.
Okay, so if it's okay with the chair, we'll pause this one and move on to candidate B.
Yes.
Okay.
Please tell us about candidate B.
Okay, and I would also like the record to reflect that Commissioner Torbett is now present. All right, candidate B, we have Quincy Mole with principal broker Laura Gaither. Is she present? I believe I see her. Mr. Mole is present before us due to a felony with a felony of intent to sell and deliver cocaine. Mr. Mole's statement can be found on your iPads. Chairman Diaz.
Thank you. Mr. Mole, please explain the circumstances that cause you to appear before us today.
Oh, yes, sir. First of all, I'd like to thank you guys for giving me the opportunity to be here today. It's truly a blessing. And I want to thank Ms. Gaither for supporting me as well. This accident happened in 2006. I was 24 years old. I was hanging out in the neighborhood with a group of guys, and we were involved in a drug transaction, and a warrant was served, and I was caught. I received probation in 2008, I'm sorry, and since then I have gotten off parole. Been working full time. Also have an interest in becoming a real estate agent to lay a foundation down for my family. I'm a father of 4. I have 2 grandkids. I've been married since 2011. And it's just a part of my life I wish I could put behind me, but somehow it always finds a way to come back. And I don't want to hide from it. I don't want to glorify it. I just want to embrace it and learn from it and try to be a better person. And that's what I'm seeking to do.
The original incident finished in 19. Okay. Commissioners have any questions for Mr. Mole? All right, hearing none. Ms. Gaither, please tell us about the reasons why you would like Mr. Mole to be part of your firm.
Good morning. Quincy, I met him in July when he was going through his real estate courses, so we didn't have a personal background. But in September, I learned of his prior conviction, and before that, when he had applied, and after, he has been a part of our office. He's been here attending training, doing our sales meetings, not just here in my office, but also at our corporate office, doing, different like ninja selling and different types of training. He's also taken on not 1, but 2 mentors with different backgrounds. So he's got one very seasoned agent and one that has been licensed for about 10 years. So he's gotten really involved. He seems very eager in learning and being a part of it. And I know he's embarrassed about this and wishes it wasn't here, but I think it'll be a good fit, and I'm excited to have him and hope to be there along with him to prove that he's changed.
All right. So tell us about, you talked about the training at your firm and things like that. Tell us about your supervision and the ongoing training of new licensees. How does that work at your firm?
So in my office, we have a training every week, every Tuesday at 9:30, not holidays, but typically every Tuesday at 9:30. We also have training in our main office 3 times a week, or a quarter in our corporate office. And then there's also 24-hour online training and availability, and of course they can always call me. And then we have mentors as well.
And how many agents are under your supervision presently?
52.
52. Okay. Any commissioners have other questions? All right, hearing none, I sense you're ready to vote. Is there a motion?
So moved.
And the motion is? I have a motion to approve. I have a motion to approve by Commissioner Tucker, seconded by Commissioner Gwynn, that we approve this candidate. All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, Mr. Bull. Do Ms. Gaither proud. You're free to listen to the rest of the meeting if you want, or you can go about your day. Have a Merry Christmas and take care.
Thank you.
I talk to
Mr. Price, is your broker present?
I'm not able to reach them right now. Is there any way that I could reschedule? I guess I apologize for this.
We can do one of two things. We can either reschedule, but if you're able to get in contact with him within the next 30 minutes or so, when appropriate, we will hear from your broker.
Okay. And then should I just stay on here and let
Yes.
you guys know, or try to
Yes.
get?
And
Okay.
if he won't be in attendance, if you would just type that in the chat, and then we'll move on and try to reschedule you for January. Is that
Okay,
o-
I
is that
really
okay
appreciate
with the
it.
chair? Is that okay with you, Chair
yes,
Diaz?
yes.
All right. Thank you, guys.
The next item on our agenda is a waiver request.
Yes, we have a medical waiver request from Miss Linda Brandon. She is seeking a waiver of retesting due to medical care. Her license expired June, I believe, 22nd of 2022. And her statement is, and her records are on your iPads.
Okay, so license expiration date, that means she had since June of 21 to renew her license and get her education?
She did get her education, but she did not renew her license before June of 2022.
At the 1 year mark, or is June
It's
of
past the
23?
1 year mark. She contacted our office in September of 2023. So she is over 1 year.
1 year.
1 year would have been June
23.
of 2023, yes. So at this point, she would need to retest.
Questions?
Raise your mind, after 1 year, you have to retest. That's in our laws, right? Or in our rules.
Yes, according to the rule 1260-01-.21, it states if past 1 year your license has been expired, you're required to retest and reapply.
Oh, and then there's also the accrual of late fees and such in the ensuing year.
Correct.
Have those been paid, or?
No.
But the waiver request is specifically for retesting.
Are those fees still pending, or?
They would be if you were to reinstate her. It's about $1,100. However, our rules, the way they're written, after a year, you have to retest and reapply. So we don't have a mechanism to charge her after the 365-day mark. And if I'm not mistaken, she has been expired at least 467 days. Correct. Will you please restate your question for the record?
So if she retests, she doesn't have to pay the late fees.
Correct. Not only does she have to retest, but she also has to reapply.
It's as if she's like a new agent, basically. I mean, she's severed her.
She'll get a new license number.
She get a new license number.
She wouldn't
don't have-
necessarily
what about
receive
what about
new-
education?
She already has the pre-licensing courses. I would have to double check, but I believe she already has the pre-licensing courses. She doesn't have to retake those.
But she would lose her grandfather status for CE.
But she, if I'm not mistaken, is she not?
It was 88 was her first license. Is
Yes.
that grandfather?
Mm-hmm.
Yes, if you're expired for over a year, you do lose your grandfather's status. But you won't receive a new license number.
Okay.
You need to be able.
Not that you're doing that or anything.
I do have sympathy and compassion, but I don't think we're in a position to change the rules.
I don't have any more questions. I will entertain a motion. How do we feel?
Can it be communicated to her that she's pay less in fees to take the test again?
I don't think in the space of this meeting it can be.
Will you repeat your question? I apologize.
I'm still trying to figure out. So, if we waive the retesting, how much is she going to have to pay in late fees?
According to we can only charge. It's my understanding we can only charge up to $1,100 because that's what's written in the rule. Up to 365 days.
So, if we waive the retesting, she pays $1,100. If we don't waive the retesting, she just starts over and there's no fees. But she's lost all of the benefits of being grandfathered in.
So
Can we waive a rule?
in our discretion, yes, we can. But we also worry about precedent.
If she's retesting, reapplying, then there would be the fees associated with that. The waive is not a sum zero. And unfortunately, in this particular instance, there's not really discretion for the commission to waive this particular segment of the rule.
But the $1,100 worth of late fees, they would go away if she had to retest. Believe so.
Yeah.
So that's in the pantheon of attorney responses. Yes, no, yes, and no, and it depends.
I don't want to give you a wrong answer. Like if it's supposed to be, it'll be assessed. If it's not, it won't be.
So let me ask you. Let's continue with the hypotheticals then.
Sure. All right, let's go.
If we were to have her retest and the fees apply,
Yes.
would she be able to then come back and ask for a waiver of those fees?
I don't believe so. No, that wouldn't be retroactively asking.
Okay.
No.
Okay, we're
But that's
struggling.
not what that's not what the waiver's for.
Right.
Specifically, they're just asking for the testing waiver. Because that's always usually typically what the waivers are for is people pay. They don't want to take tests again.
Right.
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 This has been this is in the 80s.
Reading her last sentence, says, "Sorry I've been so detailed in this request, but hope that you would understand after hearing details and grant me this waiver that I might retire my license in good standing after 35 years of being a realtor." So is she wanting, what is she
It's
talking
my
about?
understanding that she wants to become compliant and then pay the
retire?
fee and then retire her license.
Oh.
But she could take it out of retirement the very next day without the retesting that would have been required at the 366 day mark.
I
Say
think
that again. Ah,
I think
So she thought she had paid her renewal fee.
Correct. According to Miss
But-
Brandon's
She
statement,
can't find proof that she thinks she did.
we do not have record of a payment.
I think since we really can't waive this rule, that I would make a motion to deny the request.
Okay, I have a motion by Commissioner Gahn to deny this waiver request, seconded by Commissioner Gwynn. Any further discussion?
Well, I have a question. Again, we have the authority.
You have the discretion, but precedent-setting concerns are also present.
My understanding is the late fees still apply. So those would not go away. And if she were to retire, there is a fee to retire as well.
Get any discipline?
I can look. No, there is not. It's on the fee. That's on the sheet.
I think that we have a motion and a
Yes, we
second.
got a vote.
We do? Any further discussion? Hearing none, let's vote. All those in favor of the motion to deny this request?
Aye.
Aye.
Any opposed? That motion passes on a 7-1.
We had 2 no's.
6 to 2.
6-2. I apologize. 6-2 vote.
May we have the two dissenters? 5 to 2.
Yeah, it's 5 to 2.
We cannot count today.
Because Joe's not here, DJ's not here.
5-2. So the no votes were Commissioner Torbett and Commissioner Moffitt.
Thank you. Really quickly, and I'm sorry if I'm going out of order, but candidate A, Mr. Price, just informed us his principal broker will not be in attendance today.
So do we need to do anything to
So
defer?
Mr. Price, we can reschedule you for January.
Okay, I really appreciate it. Thank you guys for your time. Have a great morning.
Thank you, Mr. Price.
Oh, the next item on our agenda is the Executive Director's Report. Mr. White. I'm sorry, Education Report. Yes. Good morning.
Again, happy holidays to everyone, and especially I think at this time of year we'll acknowledge that we have the very best staff in the state of Tennessee sitting behind me. Just wanted to, I'll call your attention then to your iPads and the education report. I have I present them to you, D1 through D56, for your approval.
Thank you, Mr. White. Is there any courses that commissioners would like to pull out for discussion? Hearing none, is there a motion? I have a motion by Commissioner Gwynn to approve the education report, seconded by Commissioner Tucker. All those in favor?
Aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously.
Thank you, Mr. Chairman, members.
You have an instructor for us to approve?
One instructor for your approval today.
Anything you want us to tell about Ms. Stoddard?
Present her for something's wrong, Mr. Chairman, members of the commission, but I keep hitting and goes in and off. I'm having one of those mornings.
We all are, Mr. White. We all are. Got that?
Well, thank you. I'll try to comport my decorum here. Yes, Melissa Stoddard, I would just present her for your approval this morning as an instructor. I've reviewed her qualifications and achievements. Basically, she is own consultant and sales manager. Of course, company in on your, actually she beginning a providership of herself this morning, and I believe that's on your agenda as well. So I present her for your approval as she comports with all the rules and regulations.
Thank you, Mr. White. For a motion. Is there, I have a motion to approve by Commissioner Torbett and seconded by Commissioner Smith. All those in favor say aye.
Aye.
Any opposed? Hearing none, that candidate is approved. Thank you, Mr. White.
Thank you, Mr. Chair.
Baker, your report.
Good morning.
Good morning.
Thank you guys for being here today. As you will see on the executive director report that's on your iPad, it involves some changes. We'll be tweaking this report, and we should have a new report for you in January. But you do have on your iPads November's numbers as it pertains to exams taken, as well as the profession count, as well as your open and closed complaint report. You will notice a high number of complaints closed, and a lot of those have to deal with E&O insurance. Are there any questions about the charts before you today? Great, I will continue. Staff will be making arrangements to attend Arella's mid-year conference in New Orleans. We typically take 1 or 2 commissioners with us. During this conference, they will not be offering Commissioners College for some of our newer commissioners. However, if 1 or 2 of you guys would like to attend the conference in New Orleans on April 16th through 18th, please let me know, because we'll be getting those arrangements sooner rather than later. And just a note, Commissioners College is also available online for those who want to partake in that training. TREC commissioners will be asked to sit on a panel on February 20th with Tennessee Realtors, and there will be a formal invitation forthcoming. Revised PSI reports for 2021 through 2023 will be presented at January's commission meeting with a full recap of 2023 submitted for the commission's review. So we're still working out the kinks with PSI, but we'll have all the finalized reports from 2021, 2022, as well as 2023. I would like to pivot for a moment from my typical report, if that's okay, Chair Diaz.
Mm-hmm.
I'm pleased to share, or I am pleased to be here with TREC team members today. Combined, these 10 public servants have over 100 years of state of Tennessee service. With the help of investigators, a customer service center, our legal department, and a host of others within TDCI, they ensure that real estate licensees in Tennessee receive the best customer service and that consumers have resources when needed. TDCI's mission is to serve our customers through balanced oversight of insurance and regulated professions while enhancing customer advocacy, education, and public safety. These folks do that every single day. As I call you by name, will you guys stand for a moment, please? Aaron has been with the state for 7 years, and he handles all things that prepare us to meet collectively as a commission. He is instrumental in making sure we are able to gather on a monthly basis. Thank you, Aaron. Amy has been with TREC for 5 years, and she is our E&O expert. So this time next year, we'll be relying on her heavily as it will be E&O renewal season. Denny has been with TREC 4 years and is an expert on all things as it pertains to getting out-of-state licensees informed of TREC requirements and to be licensed in Tennessee. Miss LaRosa has been serving Tennessee since 2016, and she helps process applications and helps Denny with out-of-state licenses, or licensees rather, excuse me. Megan has been with TREC for nearly a year and provides excellent customer service on a daily basis. Rachel who used to work in this room by that window that Commissioner Gahn is sitting by, has been serving the state for 26 years and is she's really the jack of all trades. She has a superior understanding of TREC policies and helps train new employees as well. Miss Rhonda has a heart for service. Not only has she worked for the state for 10 years, but she also has 8 years of military service. Scott has been with the state for 5 years, and he assists us with processing applications and reviewing data with Orelo when needed. Rihanna is TREC's administrative manager. She has worked in a variety of capacities. She has worked in a variety of capacities within TDCI in her 13-year tenure with the state. She also helps hold us all accountable. I can't speak this morning. She holds us all accountable, and is knowledgeable about all things TREC, especially our internal processes. She also keeps our train moving by handling employee scheduling. Mr. Ross White, as you guys see him on a monthly basis, has been with the state of Tennessee for 34 years in a variety of capacities. He often tells me this is his favorite job since he's been with the state. And last but not least, although she is not in TREC per se, is Miss Carol. She has been with our legal department for 6 years and helps support our outstanding legal team. So with the help of everyone within TDCI, these folks keep the TREC train moving. So thank you for allowing me to present them today. I am overjoyed that I get to work with these folks every day, and I hope Tennessee licensees are proud of the work that these folks do every day. Thank you.
The only comments I'll add to that is I know that our previous chairman, Mr. John Greaves, always complimented the staff in terms of clearing out a large backlog and keeping up current with our workload. And I know that these folks that are here today that were just recognized are part and parcel of that. So I want to thank them for that. I know our licensees appreciate it, even though they may not appreciate our decisions. At least we get to them and get to them quick. So again, thank you. Happy holidays. And I look forward to our luncheon later today where I can talk to you more directly. So thank you for that. Ms. Baker, anything else? Thank you.
That concludes my report. Oh my goodness, sorry. That concludes my report.
Now, Ms. Baker, we were promised tech upgrades to this room.
We've all been promised tech upgrades.
All right, so that I guess the next item on our agenda will be the legal and consent. But do commissioners want to break for 10 minutes?
DJ should be here because I was texting about the parking garage.
Okay.
So
If we take a 10-minute recess, would you like to do that at this time?
All right, we will recess for 10 minutes. That'll bring us back. Let's just go ahead and say 9:15.
9:15. Very good. Thank you.
Did you start?
To reflect that Vice Chair Ferris is now present.
Thank you for that. Okay, so this month's consent agenda, commissioners have chosen to pull the following cases. Cases 1, 3, 6, 7, 11, 30, 31, 34, 35, and 59. The commissioners wish to pull any other cases? Hearing none, Chair will entertain the motion.
Make a motion to accept council's recommendation with the exceptions of the numbers clarified earlier.
I have a motion to accept council's recommendation for the legal and consent report minus the cases read into the record, seconded by Commissioner Moffitt. All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously. So we are going to start with case 1. I think that's one I pulled. Okay, so this case you had it as a self-report. So this person hasn't committed a violation in the state of Tennessee yet. or if ever, right? So are we just establishing a record for him so that we know his history?
We're
Or
required to report
Okay.
changes, and then it's an administratively open complaint. So
Okay.
after reviewing the disciplinary action that was put on this respondent by the other state, I felt it didn't rise to the level of us needing to take any action other than a letter of warning based on the circumstances.
for a motion?
To approve council's recommendation.
Motion to accept council's recommendation by Commissioner Smith, seconded by Commissioner Torbett. All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 3. I'm the only one that had that one? Yes. Okay.
I did not pull it, but I questioned it, and my question for me on it was this a situation where this should be investigated? Did you pull it also?
I did pull it, but I only pull it because I like to know what the topic of the letter of warning was. Number 3?
Previous letter of warning.
Yes, ma'am.
Answer Commissioner's question. I did not feel like it rose to that level. There was a history of cross complaints, and that were previously before the commission, either last month or the month before, that was dismissed. So I think it's just a falling apart and not something that rises to the level of needing investigation by the commission.
The reason I think, let's see, is because doesn't it say something about them not having some of their? Let me read over it just a second.
The original complaint was that they were not keeping the records for the 3 years like they were supposed to.
Yes.
But other than that allegation, when they were provided an opportunity to provide additional documentation or proof of anything, it did not respond. And that's why I felt like it was a cross complaint.
For a motion, Commissioner? A motion to approve council's recommendation to dismiss, seconded by Commissioner Ferris. All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously. So this is the first, case number 6 is a discussion case. Do we want to take it now, or do we want to push it to the end and get through the others? And take it now? Okay, case number 6. Council, tell us about case number 6.
Okay. For you all. As you can see from the licensee's history, there is a history of disciplinary action here. In this case, we have a complainant who has the power of attorney for their elderly parent. They are trying to sell a piece of property that they own, that there's a mobile home on, a decrepit mobile home, that the complainant didn't even realize, I don't think, that anybody was living in because it was in such disrepair. They contracted with the respondent licensee to sell the property. And after that, things get kind of murky. I feel like we have a experienced respondent with a non-sophisticated complainant. I kind of had to walk the complainant through what the purchase agreement was and what that entailed. There was a sales contract. My point is that things got complicated, and I don't think that the complainant was in the best position to understand what was happening when it was happening. So complainant enters into this contract with the respondent to sell the property in June of 2022. Complainant signs a purchase agreement or sales contract with the respondent, who says they will purchase the property for an amount, and the sales contract states that the respondent is responsible for moving any tenants. Apparently, that by that point they had figured out there may be somebody squatting in this mobile home. So respondent took responsibility for that in the sales contract. The money was not, the sales proceeds were not dispersed to the complainant. The complainant then finds out at the beginning of 2023 that the respondent had turned around and sold the property again to buyer for an amount almost 1.5 times what complainant sold it to respondent for. But complainant still doesn't have their proceeds. June of 2023, complainant still does not have their proceeds. When contacted, the respondent stated that the funds were in escrow and would be until a bill of sale was provided from complainant to the respondent for this mobile home. They also, the buyer is now in eviction proceedings against this squatter. As of 2 weeks ago, when I again followed up with the complainant, they still do not have their funds. The last that they heard from the respondent was August of 2023, when respondent said that they would get back to the complainant. So it's now been 1.5 years, and complainant still does not have the proceeds from the sale of this property.
Oh, the respondent closed on the property with complainant, and proceeds were dispersed to escrow account?
That's what respondent is claiming. Complainant, as I said, is an unsophisticated seller. And they say they never attended a closing. They never got notice that there was going to be a closing. They just have respondent saying, I'm going to buy this property from you. Here's the contract, sell it or sign it. And then they still have yet to see the proceeds from either the sale of the contract to the respondent or the sale from that the respondent then did to with the buyer.
So the respondent has a sum of money in escrow, waiting to finish the purchase of
That's what they're
this
claiming.
property.
But the respondent also has resold the property.
Yes.
So was the trailer part of the contract in the purchase agreement with the first contract?
Yes, sir.
Was it part of the second one?
From a respondent to buyer. Let me fill up the deeds.
Well, the respondent sold the contract, so the terms in the contract would go to the new buyer, I would think.
Unless stipulated otherwise. Yeah.
Looks like yes, sir.
But a deed was recorded when it sold from the complainant to the respondent, even though the complainant was unaware?
The deed was not recorded until buyer purchased the property. And then in January 2023 is when this deed was finally recorded that the complainant thought was done in June of 2022 to respondent.
I got you.
So does that mean that the complainant still owns the property?
Yeah, it is. The ownership of the property now is in the name of the eventual buyer. The complainant doesn't know when that deed was prepared for in the name of the third party buyer. The second buyer, yes, ma'am.
No closing documents with the complainant's signatures on it at all.
No. They said they'd never seen a closing statement or an alternate, none of that. And
But the respondent doesn't have closing documents with the complainant's signature on it.
They sold the contract.
The contract.
I also have the complainant when they were notified of the respondent's response, which said, I'll disperse the proceeds as soon as I have a bill of sale. This complainant's response to me was, that's the first I've heard of that they were waiting on a bill of sale. And again, this would be
I had no.
I don't see how they could have recorded a deed and not had let the funds go. I mean,
It sounds like the respondent got his money from buyer, but respondent has not given the money to complainant. Is that where I'm standing right now?
Yes, sir.
But the respondent is holding the complainant's money in escrow pending the bill of sale.
They just now notified
Just now
through the
notified.
commission's response that that's what it would take to get the proceeds dispersed.
Did the respondent assert that they made that clear at the onset that they would needed a bill of sale?
No, not in the documents that I have.
Not in the documents that you got.
No, sir.
Question. So the respondent is a principal broker since 06, correct? And so what is the complainant saying? Can you state what is the complainant saying that he or she sold a piece of property and didn't get the money, yet the deed was recorded?
Yes, sir. In the third party buyer's name.
But why is she not going after she's the seller, right?
Yes, sir.
Is she
On behalf of-
is
on
she
behalf of the
represented by
parent.
an attorney or anything?
No, sir.
But the complainant is the power. Oh boy. Okay.
What is she saying the broker did in error?
Their money for now.
How could a broker
year and
do
a half.
that?
Because
Is a broker also the buyer?
yes, sir. In an intermediate transaction.
Oh.
This is an off the wall question, but when you get these, if you feel like there's enough evidence that they should seek legal counsel, do we have the right to say that, or do we just deal with what we have?
I would advise them, and I have, to pursue any and all legal options they may have. I can't sit there and tell them what those legal options may be. But
you can say,
when I feel warranted, I do let them know they may want to talk to someone. Yes, ma'am.
Thank you.
If I feel like, thank you. And if I feel like there may be grounds for a criminal referral, I have done that as well.
But not in this case yet.
That's under deliberation.
Under deliberation. Okay.
So, public member and unfamiliar with selling the contract, how does that work? How do you, like, to me this seems a little shady. So how do you sell the contract without the owner knowing that you sold the contract?
Well, usually, and counsel, correct me if I'm wrong because I'm not an attorney, but usually in the contract it states that the contract is assignable, but that phrasing allows the prospective purchaser to then shop the contract around and say, I have this interest to purchase this property. Would you want to buy it from me for some marked up price? So let's say I offer some amount to the owner and they sign that agreement, and then I shop it around and add my profit into the price and say, will you buy this contract from me? And then the contract is then assigned to this new buyer. And I think ethically the agents and licensees should disclose that to the other party.
My question is, how do you do that without the
So the complainant would have had to have signed off on a closing and signed off on a deed transfer to the respondent before the respondent could send it to that person. I don't see how they got around that.
It seems like they've been taken advantage of.
I agree, Stacy. It does seem that way, and unless there's something more that the respondent hasn't shared, that from their perspective was the respondent in any way, Kim, did they provide any details of how, just to go along with what they have provided here about they thought they were in the best position to help get the property sold in lieu, with the trailer and eviction of the squatter, the homeless relative, and did they start out with good intentions? Was it apparent? I mean, I know you can't, I know you don't know, but
The the respondent certainly seemed to imply that they thought that they were helping out the complainant. The complainant, I believe, had already been in a friendly relationship with the respondent, which is why they approached them to help them sell the property.
Do you have a copy of that original agreement between the seller and the first buyer?
Yes, ma'am.
Does it say in there anything about a signing of the contract? Actually, this is a form of wholesaling we've talked about before.
I can't figure out how the deed got transferred without without signed paperwork. There's something shady going on there.
It does not say anything in the contract about a signing, but I don't know that I have the full document. Yes, ma'am.
Council have any recommendation in terms of statutes or rules that may have been violated?
Yes, sir. Go to TCA 6213-403, subsection 6. The respondent would be responsible for timely account for trust fund deposits and all other property received from any party to the transaction. I think a year and a half later, not having a good explanation for where the proceeds are, and we have a complainant, a seller who is still confused about what they're supposed to do and is not getting much help from this respondent who does owe a fiduciary duty to this complainant, at the very least that they would be in violation of that.
It's around page 40.
6213.
The statute
Page
is
50.
6213-403.
Page. You do have a listing agreement in place.
At the very last, it says the respondent would release the funds if the complainant will provide a bill of sale on the trailer and said property if the court case is closed. What court case is that? The eviction?
Yes, sir. The squatter that's on the property, the third-party buyer had to enter into eviction proceedings to evict the squatter because they had been there for such a long period of time. They were claiming they had some right to.
So do you think the brokers, the response kind of using this as an excuse not to release the money?
I can only speculate. I can say without a doubt, because I have the statements from both, that the respondent did not make this statement until after receiving the complaint that's before you, and that the complainant's response to that was, that's the first I've heard of that.
At the bill of sale?
Yes, sir.
So without the complaint coming in, the respondent and the buyer would have just, we can presume, they would have just continued to go along. Maybe the new buyer gets the people evicted. Maybe they don't. Maybe they wander off. The respondent has the proceeds in their account and are just going to,
I can only speculate.
Right. I mean, that's what I'm
it's been
doing.
a year and a half, and we still don't have a resolution. So.
Right.
And so, I'm sorry, Commissioner, just saying, so the court case is a civil case then, obviously?
Yes. Yes.
Okay.
So was she's selling the fee to the ground, and it just so happened that there was a trailer sitting on it with a squatter that say the trailer's worth $0. So the title, how is the title affected on when you have a trailer sitting on there with a person in it that you can't get out? Is there a lien on it, or is it, you see what I'm saying? In other words, you're selling The trailer is personal property, right? Or is it real estate? It's not real estate. It's a mobile home that you can hook up on a truck. I mean, you can unhook it from. So we don't know that, do we? So do we know if the trailer was real estate or if it was personal property? We don't know.
I do not know, sir. All sold as one lot.
Here's a question about the complainant statement. And here it says complainant provided copies of the deed they signed.
Yes, sir. So, Mr. Gahn, Commissioner Gahn, you had a question about that. So there is a copy of a deed that purports to be from the complainant that does name the third-party buyer. Complainant, when I asked them about that, said that they had signed a deed, but that it was back in 2022 after respondent told them to sign this. The date of the deed says November 3rd, 2022, conveying property to this third person. The respondent says, well, they didn't actually want to pay for it until January of 2023. So the deed is signed November 2nd, 2022. The respondent says, I got my money in January of 2023. And lo and behold, that's when the deed is finally actually filed. There's a notary date that says January 19th. The complainant would say they never sat in front of a notary. Respondent handed them a deed, had them sign it, and then they went about their way.
How they got around.
It's almost on the up and up.
Yeah. Horseshoes and
Yeah.
hammers.
There was the signed deed, but it was not signed as it ought to have been signed, sounds like.
A notary problem, too.
Yeah.
When the respondent provided their copy of the deed, they just provided me with the last page, the notarized page that says January 19th of 2023. I got the full deed from the complainant.
Okay. The full deed came from the complainant. The respondent shared the last page.
Last page.
Any chance the respondent was a notary?
Different name, but you never know.
Oh, and
Me too.
then we also have a consent order for failure about a commission check. So I guess tying all this together, it sounds like money issues.
So yeah, so we got 21 and 22. One's for a commission tax, one's for a lapse of E&O insurance, and now we have this. So this guy's got he likes to visit us annually, apparently. Well,
Do you
know,
think,
now we do have this full spectrum of discipline that we can put out. So I'm gonna we have civil penalties, of course. Then we have suspension and revocation as options, if commissioners feel that it rises to that. Is there any other statute or rule that you felt were appropriate here, Council, besides 6213-436?
General due care.
General due care.
Requirement of all licensees.
So that's
Is there a way we can force them to pay the complainant?
You know,
So, in other words, they're going to have to sue them to get it. Good.
let's get a motion on the floor, and then we can keep discussing if we feel the need to. Is there any motion that a commissioner wishes to make at this time?
I do.
Go ahead and make it.
I do. I just don't know how deep I want to go.
We'll make the motion, and if you get a second, we'll see what commissioners feel.
I'll make a motion. I'll move to revoke this licensee's license.
ooh,
Given the lack of skill of due
I'll second that.
care, due diligence.
Have a motion to revoke this licensee's license by Commissioner and Vice Chairman Ferris, seconded by Commissioner Gwynn.
And we also find them.
Uh, well, I understand the reflex and want to beat this licensee into the ground, but I don't think so.
Well, and I'll make another remark that I'm taking, as we all are, taking this very seriously on its face, and that if the respondent has other information that puts this in a different light, then they are called to come before this commission to present their case, so that we can understand and be
That's true.
Yeah, to prove that if this motion has warranted or not, as proposed and is seconded.
The reason I was thinking the same thing. The reason I seconded it, because I think that's the only way we can get to the bottom of this, is to have the respondent come in here and get in documents and look at this in more detail. It's too complicated to. I mean, we're almost acting as the complainant's attorney. It sounds to me. I mean,
oh no.
Why does she not? Why does she not go hire counsel?
I cannot. I'm your legal counsel, not hers.
Right.
I can't tell her what she needs to do, and I can only say that there are other legal options available to her, and I would encourage her to do that.
Obviously, if this vote passes and this person gets this notification, they're going to want to come before us to explain things, because if we vote to revoke the license, then that person is notified that the license will be revoked by a certain period of time. Is that correct?
It's an consent order, so it's an offer.
It's an offer.
It's an offer to,
right.
Yes, ma'am.
So really that offer is, we're suggesting revoke your license, or you can come explain more. Basically, it's what it is. Okay, I'm good.
Yeah, again, I welcome this respondent to come, if this motion passes, and show that they did diligently exercise reasonable skill and care, and that I'm mistaken in making my motion to revoke their license. But at this point in time, it seems like the consumer in this instance has gotten the short end of this deal. But perhaps I'm mistaken.
Now, I would also welcome that opportunity to learn that this is all just a big misunderstanding,
Right.
because it seems pretty egregious.
Yeah, and I mean, and the respondent does say here in their response they regret this happened, and I'm sure they do.
About to do it.
Yeah.
So do they continue until they come before us, or is their license automatically revoked?
We can't do an circumstance and given the opportunity to.
How long do they have to do that?
30 days.
Further discussion.
I would just say to the commission, this is the first time I can recall in my 2.5 years of making a motion to revoke a license. But I hope we don't have to. I'd like to give this respondent the benefit of the doubt, but we need some more information.
Any other further discussion or comments? Hearing none, I sense you're ready to vote. I'll restate the motion. The motion is to offer this licensee the revocation of his license or their license. And that was by Commissioner Ferris, seconded by Commissioner Gwynn. All those in favor?
Aye.
Any opposed? Hearing none, that motion passes unanimously. So the next one is 7. Commissioner Smith, that's yours.
The reason I pulled that is on the second paragraph, respondent stated that complainant entered the property without seller's permission after receiving the lockbox code from complainant's agent. And we run into this issue before, giving out lockbox codes to buyers without permission. Keys, access,
Yes, ma'am.
codes, door openings, whatever. But the bottom line is, we have, if I'm reading this correctly, we have an agent who gave out access to property without the seller's permission. Is that correct?
That is what the respondent is alleging. The complainant is alleging that they had permission to go in and inspect regarding potential repairs because the complainant themselves is a contractor and so wanted to see what they were looking at essentially in regards to repairs to the property.
Sorry, the complainant
Is a handyman contractor that
and
was going to do their own repairs if necessary.
they're the ones that they're the buyer.
Yes.
Are they an agent?
The complaint, no, was just
Complainant's agent. Okay, sorry.
Yeah.
The question I had about this case, I didn't put it on there to be called, was have you seen the new disclosure form that the buyer with the respondent?
I have not
Okay.
heard that they did.
I almost feel a letter of warning for due diligence is in order. So I'm going to make a motion that we send a letter of warning based on giving access to property without permission.
Motion by Commissioner Smith to issue a letter of warning, a violation of Tennessee Code Section 6213-431, reasonable skill and care.
But is that not the complainant's agent?
Yeah.
How do we do, I mean, you have to open a case against the complainant's agent, wouldn't you?
Tenant's agent is
Right. That's correct.
Like there's an amendment to the motion.
what do we do that?
That's just what the respondent has said in their rebuttal. I think the big question here is, was this, I know the property was sold as is to the complainant, but before the closing occurred, the complainant decides not to purchase the property. And so they're not going to they didn't buy the property, but they're questioning, they want their earnest money back. Respondent is saying, you breached the contract, so we're keeping your earnest money. So this is better suited for a court case for them, in my opinion.
And there is one pending.
Okay.
Pending the earnest money.
So I think your recommendation to dismiss is, I think
Withdraw my motion.
I think I support that because the complainant can make their case in court that this property was not in the same condition in which they contracted it. They weren't going to buy it and give me my earnest money back. And if they lose that, they lose their earnest money, but they didn't buy this property. So, right, yeah. So, I don't know. I'm not going to say worst case, best case scenario about a case that's not even in court, but I make a motion to.
Well, hold on.
I withdrew my motion.
Can it be withdrawn like that, or do we have to amend?
I don't believe it was seconded, so.
It was by Commissioner Moffitt.
Oh, I'm sorry. I misheard.
Okay.
He can withdraw it. All right. So Commissioner Smith's motion is withdrawn. Commissioner Ferris, is there a motion?
Move to accept council's recommendation on case 7.
Second.
I have a motion to accept council's recommendation to dismiss this case by Commissioner Ferris, seconded by Commissioner Torbett. All those in favor of that motion?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Number 11, that's mine. What I say. I don't have an issue with council's recommendation. I'd also would wonder if there should be a second penalty for failure to respond.
They have not been licensed and licensed responsible for failure.
Oh, the expired license is the firm's license. Okay. Thank you, council. Is there a motion?
Move to accept council's recommendation on case 11.
Motion by Commissioner Ferris to accept council's recommendation on case number 11, seconded by Commissioner Tucker. All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously.
So I have a question, just a general question. If someone just continues unlicensed activity, what do we do?
Question, council?
If you have someone that's just unlicensed and continues to do unlicensed activity, what recourse do we have other than just keep on civil penalties?
It could technically be both a crime to engage in unlicensed activity, but it's also civil remedies are available to the commission, and that would be the Attorney General's office responsibility to move forward with an injunction, a cease and desist, those sorts of things.
For example, I had a case that went to hearing, and for unlicensed activity that included cease and desist language, and the individual continued to operate in unlicensed activity. So the Attorney General's office sued them in Chancery Court. So we have ongoing Chancery Court litigation with that individual because they have violated the administrative law judge's order. So we do have other remedies related to that.
Hammers do get.
No.
Moving on to case number 30, which is a discussed case. Counsel, tell us about case number 30.
Yes. So there's a lot going on in this case, but
yes,
in a brief overview, as brief as I can get it, essentially the complainant is saying that they felt they were misled by the representations of the respondent, and they purchased a property that doesn't have any power to it now. There was based off the complaint, they're essentially saying that the respondent had stated that there were electric poles. They had advertised it in a video, the MLS, in multiple other ways. But after they bought the property, they discovered that there was no power unless they got an easement from their neighbor, and the neighbor refused to give that easement. And the respondent essentially is saying that they never disclosed it. They wouldn't have said that, and that there were no electric poles on the property. So why would I have to disclose it? They essentially said it's not my job to let them know that. And so I'm an investigator look to see if the electric poles were part of the original deed or if how that broke down, and essentially kind of found out that it was a large tract of land that got divided. And this is the first time that after the division, this is the first time it's been sold out of the tracts.
But was this tract of land that's in dispute with the power, was it originally part of the tract of land that has the utility poles?
Yes. It was a very large one. I think I'm not sure how many times they divided it up, right, but more than one.
I know for me, I read this case a couple of times and pondered over it a lot. And I'm always reminded by the attorney in my household and hear that words have meaning. And availability seems to be the vaguest. What it's available. What does available mean? Is it half a mile away or is it 20 feet away? So that to me is kind of, that, and the respondent seems to be relying on the fact, well, they visited the property and they could see that there were no utility poles on the property.
In their MLS listing, there's the section that I made
available.
was there's a section that says septic tank or septic system needed versus electric, which is available. And so I feel as though they knew to make distinctions. And then there was also a video where they introduced themselves on the video, and they very clearly said there is electric on the property.
On the property or available?
They said that there's like, see, I think I wrote it down, but I think it was like they have electric, water, natural gas, and they said that all that was available on the property, and it was like pretty much like ready to go. When I listened to it, I would have been under the impression that
so
like you could
your
just move
impression
in.
was they could just plug into it.
And the neighbors also had power and their other properties.
I'll turn to the public members and say, so when an agent tells you that electricity is available, how do you react?
Question is this in a subdivision or is this undeveloped land in the middle of nowhere?
It's undeveloped land, but there are houses around.
And the buyers aren't homesteaders trying to live off grid?
No, they very much wanted power, and they stated that they would not have purchased the property.
So is there an easement or an easement is there already a utility easement?
The original easement, from the first time it was conveyed, there was a section that said that there need to be electric poles installed on the property, and it was recorded. So that's there, but once they divided up the property, I don't think that language continued to run with the land, or maybe they just didn't add it, because the warranty deed that they have says that like they're taking the property as is. But
So does that easement not run with the land?
I like the way that I read the warranty deed, it's supposed to run with the land, no matter which tract it is. But it's been a little bit of time since I've taken property class.
So could that be a title issue as well?
I think so. I think it could be a title issue, but the main thing for this complaint in general was the respondents' actions and their misrepresentations. I kind of wanted just to have a discussion on, we agreed that it was misrepresentation, and if so, like how egregious was it, and what kind of civil penalty should be assessed.
So we built on land, and we knew there was no electricity, so it was kind of on us to figure out how to get electricity out there. So I guess that's my question is...
But your counsel, you're convinced that the respondent knew that these utilities were not readily available on this tract of land?
I think that they just didn't do their due diligence. It's either that they didn't know for a fact if electricity was on the property and they still represented that it was, or they knew that there was none and they just kept on going with it. But I believe that they knew. I think that they marketed it as that there was electricity on the property available for immediate use.
So is there electric available somewhere in that area?
The neighbors had the easement that they would have
So
to.
they don't have any road frontage? There's no other place they could bring electric in from?
Not that I'm aware. Like, I think there's some around, and then the way that property specifically would get it is through that easement from the neighbor.
Council was kind enough to provide us with several options, and by count 7, in terms of which statutes we could find violations of. One of them being reasonable skill and care. All of them under 403. Commissioners?
I had a question.
Go ahead, Commissioner Blaine.
How did they misrepresent? What did you look at the contract and see what it said regarding electric?
So the basis of that was there were a couple of documents that were attached by the complainant and their agent. So the agent believed that there was electricity, and they believed the respondent was saying that there was electricity on the property. The MLS listing said that electricity was available compared to the other options where it said something was needed on the property. And then also there was a video that the respondent shot that said there was electricity available on the property.
So were they buying it to build a house on?
I believe so, yes.
So, I don't know exactly what they misrepresented. I mean, if they said that electric is available, that's a very loose term, meaning, okay, you got to get with the utility company and you're going to build a house, and you got to run your underground and all the things that go along with building a house.
Yeah. So again,
That's why I wanted to have a discussion. I just didn't know.
Well,
Right.
the whole
extent of-
absence of power poles means nothing to me because
Could be underground.
new build, you're not going to see a power pole. So I wouldn't think, oh, there's no power poles, there must be no electricity.
But yeah, so I guess it's the question, like the respondent clearly has one definition of available in mind, and the consumer has another definition of available in mind. They don't
Only
like
the consumer.
and the consumer's agent. They don't like I'm guessing, I'm making it up, the half mile away definition of available.
But yeah, and it's not even that it's like it's like I'm thinking out this window. It's over there, but it can't get here because of the neighbor between. So it's not available.
Well, you could run around it. You got to get with the electric company, figure it out.
Yeah, but it's not available as this was marketed. Sounds like. Like when I hear I wondered if I might need to watch, one of us may need to watch the video or read the MLS listing. But as the council is presenting it, and as I'm hearing it, as an agent and also as a person who's bought property, when it says electric available, I'm thinking it's right there for me to hook onto. And if it's available by easement, I'm expecting that to be said available by easement, which I would verify that.
You got to go, yeah.
And your hopefully your
But
agent,
right?
But the power company may not want to run the electric the way that easement is drawn. You have to go redo it. I mean, there's a lot of that goes into it.
Right, which if that more involved process is got something to be required, you would like that to be disclosed before you bought it.
Sorry, Anna. Turn my microphone on. Sometimes things come up after the fact that a respondent has no way of knowing about.
Mm-hmm.
And so many facets of a contract are the onus is placed on buyers to verify all the information.
That and their agent.
Right.
Well, I think the listing agent had a responsibility to know whether that electricity was available to that property. Just saying it's available is not, but to know for sure whether it was available to that property, whether it was an easement or it could come some other way, and be able to let the buyer or the buyer's agent know how they get electricity to that property.
I think that's a very experienced way of viewing this.
Council, does the record show that the respondent was at all involved in the subdividing of the land from the original tract? The record doesn't show that.
I don't have any
You don't believe
feeling with that, no.
I have a question before we make any motions made. The very first part of this complaint, page 30, at its June commission meeting, the Real Estate Commission opted to open an administrative complaint against the correct respondent. Can you remind me, just jog my memory of how that was?
So essentially, this was just related to another case. They had the wrong respondent listed, and when I looked into it further, I determined who the correct one was, and it was this individual.
Let's go ahead and put a motion on it before we continue discussion with a motion.
Let me count up these rules here. You said 7?
That was my count.
So, counsel, at the bottom of page 19, you say, alternatively, the respondent was aware there was no electricity and purposefully posted misleading advertisements.
Oh, sorry. I think I meant to add the word if, like alternative, like if that was an argument they're trying to make.
Okay.
Then they purposely posted something that was not correct.
So it's really, these are just
recommendation.
They're just options for like things that I think are
Hypotheticals.
potential violations based off
Oh.
all the facts that I was
To
provided.
my reading and
But-
in reaction to the conversation, it seems like 4032 might be the appropriate statute. Red book. Disclose to each party to the transaction any adverse facts of which the licensee has actual notice or knowledge.
But they're saying they didn't know this was an adverse fact.
They wouldn't say that.
I believe that will be their argument, yes, is that they shouldn't have had to disclose it because there were signs that there was no electricity on the property.
Their response to you was, of course there's no electricity, there's no poles, there's no, and the agent saw it and the buyer saw it.
Yes, and it's like, and they also say that they didn't market it that way. They didn't advertise as if it did have
Where
electricity.
was this video?
They said they
It was
didn't
posted
market.
on social media.
So the video was posted by the respondents.
Yes.
And they're saying they did not market this as having electricity available. But the listing says it.
Says it's available.
From their perspective, they're saying that
It
it
does.
could be available if they did some extra steps, but they didn't disclose the extra steps. And I feel as if a normal person was trying to buy, even if it's like undeveloped land, they'd want to know if they're going to have issues getting power to the property. But as of right now, there's no power still.
Seems to me we can do either clause 1 or clause 2 under the statute, but
Question. Do we have the ability to, not that we do it today, but to look at the video in here?
I have the video, a copy of it, but I'm not sure how to.
Like
I guess it'd be edited to like take out the identifying
Or
information.
like one of us could recuse ourselves and watch it and provide.
Well, but let's just ask the question. In the video, does the respondent state that it has all utilities, including, with the exception of septic?
They essentially said like electricity, Wi-Fi was available as well, water. Like they listed like multiple utilities. I was trying to find it in the paragraph that I wrote,
Including
but
electricity.
including electricity though, but it was included in the advertisement.
I want to see what it says.
There's electric, water, high-speed fiber internet, and natural gas available. That's the extent of it. So
again, I think the statute that council recommends that we can find something for clauses 1 or 2, in my opinion. But I'll allow other commissioners to make motions.
the complainant owns the property. It's closed. They own the property. They just have no power. So that's
Correct.
a whole different problem.
Yeah, I don't think that's before us. Just this. A commissioner want to dare to make a motion?
I'm just reading. I'm getting my thoughts together here. I'm seeing. I'm just still talking here. I'm seeing maybe 2 cases, so $1,000 each for 2,000 possibly.
Motion and see how it does.
Anybody else have any thoughts?
Well, I guess it's just pick which violation and go with it. They knew, they willfully misled. If they didn't know, then they didn't do their due diligence. So one or the other.
I would be inclined they didn't do their due diligence.
I agree.
Of a motion. Any commissioner.
I make a motion for $1,000 penalty for not doing their due diligence. 6213-403.
Clause 1. Second.
Second.
I have a motion by Commissioner Gahn for a $1,000 penalty for failure to exercise reasonable skill and care, seconded by Commissioner Gwen.
So,
I'm sorry, Commissioner Ferris.
I have a question. Are we in the discussion?
We are in the discussion portion. Go ahead.
Can we also add 1,000? Excuse me,
Commissioner Torbett, can you repeat
so
that, please?
sorry. I said, can we add another $1,000 civil penalty for violation for, in that same paragraph, the respondent did not enter into this agreement in honesty and good faith, as there is no mention of electricity not being available. So that's a different code violation.
In my mind, that's clause 2. Do you want to make a friendly amendment?
Well, I would say that I don't know how you could say they entered it in it with not being honest and good faith when they might have really thought there was electricity available in their mind, but they just didn't do their due diligence. So I don't know that I would say that the other.
Any other discussion? Hearing none, I sense you're ready to vote. All those in favor of the motion?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Is there any other motions in relation to this case? Hearing none, we'll move along then. Case number 31. Joan, that's you? I did not.
On this one, my question was, if I'm reading this correctly, was a licensed agent was advertising or suggesting the home inspector who was not licensed as a possible alternative for home inspection.
Yes.
So in that instance, we would normally have to do a personal interest or disclosure or something, would we, or not?
I believe so. They're going to benefit in some way from it. When this situation, it was kind of like more entangled from the other complaint from a different program, essentially saying that they were kind of intertwined, that the licensed real estate professional was advocating and promoting the unlicensed activity from their business and essentially acting as if they were one entity together.
That person happened to be the spouse.
Correct.
The interesting thing is the assertion that they didn't know that their spouse was an unlicensed home inspector.
I believe that's very unlikely, that they didn't know their spouse was unlicensed. And I believe in their response, they did mention that they were helping them get their license for home inspection, but they hadn't gotten it yet. But other than that, they had denied any kind of involvement with promoting that business.
Are they, this may have no bearing, but is a respondent and the unlicensed inspector, are they divorced? Are they separated?
They are working on a divorce right now. Yes. it's an active situation right now. Yes.
Oh, and thus maybe them hurts, them not knowing. I don't know. It's just
at the time of the complaint, though, they were married and there was no issue. The divorce is very, very recent.
If they were in the midst of divorce, they wouldn't be their unlicensed spouse.
I would move to accept council's recommendation on case 31.
Second.
To dismiss.
Mm-hmm.
I have a motion by Commissioner Ferris to accept council's recommendation on case 31, seconded by Commissioner Gwen. All those in favor of the motion?
Aye.
Any opposed?
No.
You're going to make me do math now? Oh, correct my count, but that motion passes on a 6-2 vote. Commissioners Tucker and Smith voting no.
You are correct.
Thank you. Case number 34. That's both you and me, John. So, just me then. Um, so tell me, counsel, what are the circumstances of the closing flag from 21? Are they related to this case at all?
They don't seem to be related at all. What I could gather from the closing flag case was kind of like cross complaints between them and the respondent. I guess they like took turns being complainant and respondent. And it essentially was that the complainant in that situation was saying that this respondent was using their name for marketing purposes, but it looks like it was from like Google, maybe confusing the names, but essentially just like a mix of the marketing.
Thank you, counsel. Any other discussion, or is there a motion?
Move to accept council's recommendation to dismiss case 34.
Second.
There is a motion by Commissioner Ferris to dismiss case number 34, except by accepting council's recommendation, seconded by Commissioner Gahn. All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 35, Joan, that is you. No, I did not.
It was also discussed.
That's a discuss.
Yeah.
My question was there a new listing agreement or a withdrawal from the first listing agreement? When I believe they went to a different company, a different firm, and there was an issue on the release of the listing from firm number 1, is that correct?
Yes. So
and then they went to firm number 2.
Yes. Yes, like just like a brief overview of like just all the things, because again, it's a very long complaint that I have going on here. But essentially, the respondent worked for the complainant as an affiliate, and while they were working at firm 1, they had a client that they were helping out with the listing. While they were still there, the client decided that they wanted to withdraw that listing, although they had the agreement for the listing with that firm. And then,
they had documentation that they withdrew the listing from that firm.
I didn't see any documentation. It just seems like all the parties agree that a withdrawal happened and they didn't want to list their property anymore. And then a couple months later, the respondent leaves firm number 1 to a different firm, and the same client essentially wants to follow them and list the same exact property. And they do, and the complainant is pretty much saying that they should have gotten permission since they had an exclusive agreement at the time, an exclusive listing agreement. And the only reason I wanted to bring it up for discussion is just kind of to see what the feelings were as far as like the division, if the withdrawal from the first time terminated the agreement, or was it still active and they should have received that permission.
Oh, that takes me to in your narrative here, you say, according to the agreement itself, withdrawing the listing terminates that agreement.
There's a provision that says that.
There's a provision that says that in the listing agreement.
In the original exclusive listing agreement. I think the issue is that they're saying it was still active. They can still sell it.
The respondent says they didn't have any access to documents from firm 1.
Yes.
But yet the client was their client while at firm 1, and the respondent is saying they don't recall that the listing initially went to September of 23.
I think it was actually yes. That's what they're saying. They're saying that they don't recall that, but I think it was the same property, based off my understanding, from the exclusive listing agreement to like the new listing with the new firm.
Okay, then I have a question. The client never received copies of that listing being withdrawn.
I don't have any copies of that. The client seems to think that they were no longer like a client of firm 1, and they pretty much said that like if they knew that, they would have disclosed it to their new agent and would have tried to get out of it. I think they also like wrote a letter on behalf of the respondent saying that they wanted to work with the respondent. They had only an agreement with them and no other knowledge until this complaint came out that there was even an issue.
For the rule you're quoting, you're to go deeper into that. That's clause 4 that you're pointing at. The affiliate will not take any listings or.
For the rules and regulations, are you talking about suggested.
1260.02.024.
Yes. Essentially, the rule that I was saying, if they, like you guys felt as if the contract hadn't terminated until September, then a potential violation of saying that they need to get that written authorization because it was attached to firm number one.
Sounds like their own agreement says that their agreement was terminated when the listing was withdrawn. Am I not understanding that correctly?
That's my understanding, but I figured like the argument could go either way, that they could still have the active listing and then put it back within their time that they had the contract.
Our sense, Commissioner.
I guess my concern is, don't we have a rule, and I would have to ask you to tell me what it was, to give documentation to our clients at all times. So the client should have documentation of the listing being withdrawn or expired.
I mean, I'm just thinking about this and would like to hear some of y'all's other opinions, but the respondent could have doubled back and made sure, asked, sought written authorization from the former firm. A letter of warning, possibly, but why didn't they do that? Is anyone's guess? Did they think this was, were they thinking just simply that the property was terminated or was withdrawn in November of 22, and then 8 months later the client calls them to relist, or later that, or the following year in February, the client calls the respondent to relist. They relisted in June. I could see how after 8 months, it would be almost easy to just move forward with the client, list their property.
Well, my other question would be, why did the complainant not call the respondent while it was listed, saying, we still have that listing agreement? Clayton had opportunity to do that as well.
Once it hit in June.
Yeah, once they saw it on the market, that broker should have called and said, hey, we have that listing, just so you know.
Right.
I've got a question. This is maybe a legal question as it relates to when brokers or affiliates move around to different principal brokers. What happens to liabilities that they may or may not have created for themselves or for their previous principal broker as it relates to the second one? Meaning, are they, is their new home, is that broker responsible for prior acts all the way back, or only to the point in time that they switched?
I understand your question correctly.
That's a good question.
Like any kind of if they had an agreement before, if the client had agreement
Correct.
prior to,
in other words,
how would they be responsible for something?
Right. In other words,
Yeah.
let's say an agent is at firm 1 and they move to firm 2, and between the time they move, there's a complaint that happened when they were in firm 1. Okay, so they come before the real estate commission, we fine them, or it affects the firm 1 principal broker. Is he on the hook, or she, for yes, firm 2 broker?
Yeah.
Or which one is liable?
So as I
Yes.
Under jurisdiction until they're released to firm two, then
Right.
they're still on the hook.
So when you take a new broker on, affiliate, as a managing broker, you're obviously trying to get, that person's income. I mean, it's their sales, etc. But what happens when things go wrong, and they went wrong on the side that they moved from, meaning firm one?
So,
Tell me if I'm wrong, but I think it's like they can't
It does?
impute like knowledge if they don't have it.
so
Is that not-
as
You
I
sure about
understand,
that?
as I understand it, a broker is only responsible for the affiliate's actions during the course of their supervision. So if you're there
Right.
for a year, anything that happens during that year lands on that principal broker. But once they move and something new happens, that lands on the new broker. So, but if a complaint comes in and it was during the time of the supervision of broker one, that is still the responsibility of broker one.
That's what I would think, yes.
What do we think, commissioners? Anybody want to dare to make a motion?
Well, they're complaining that it was an ethical issue. And are we here to vote on ethical issues?
Do ethics. So the question then becomes, who do we? Yes? Commissioners?
I know that the respondent did not have copies or access to documents. I've got all the documents from all the previous 4 firms I've ever worked for. I saw them yesterday as I cleaned out my garage. And I
have to do that to get to the Christmas decorations.
Yet again, I put them back in their stack.
You
and
kept them, right?
Paranoid.
Yeah.
About I've kept everything.
Right.
So I feel like the respondent could have known that and if there was any question, a call to former broker to say, hey, this client called me, we're going to list their property, move on. And so,
I just wanted to note that we're looking for the statute for the issue as far as knowledge of others' actions, and we did find it. It was 62-13-406, and it essentially just says that there shall be no imputation of knowledge or information among or between clients, the managing broker, and any designated agent or agents in a designated agency situation.
At 406?
406C.
406C, yes.
And Commissioner Smith, I think the statutory provision that you were looking for related to documents is the one in 312B8, which is talking about failing to furnish copy of any listing, sale, lease, or other contract relevant to a real estate transaction to all signatories of the contract at the time of execution. Is that the one?
if I made a motion, it'd be a letter of warning, but I'm more inclined to make a motion to dismiss. But anybody have any thoughts? I'm not the only motion maker up here. In fact, I make very few.
Your pleasure, commissioners.
We'll do this, right?
But I'm
Make a motion to dismiss.
I have a motion to dismiss. Is there a second? Second. I have a motion to dismiss by Commissioner Gwynn, seconded by Commissioner Moffitt. Is there any further discussion?
I think the discussion is that we, as a licensee, I've been educated in CE, and when I got my license, and since that you cannot take listings from your broker when you move to a new firm. And I don't think the respondent would question that. And I think the respondent felt that they were able to list this property based on what we've been told. So, yeah, that's just that's my discussion on this.
Any further discussion or comment? Hearing none, I sense you're ready to vote. All those in favor of the motion?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 59. Council, tell us about case 59.
Sure.
It's good to hear from you today, Anna. Thanks for participating.
It's me. So I've got some information to share with you guys, and I'm just going to read it because we have time.
We do.
So this is one of our E&O cases. So as you know, we opened many E&O cases throughout the years and months, and this is one of our older cases, and the respondent requested that I present this matter to the commission. So they were already sent a consent order, and we'll just see where the facts take us, all right? So on or about January 29th, 2021, the commission suspended respondent's affiliate broker for failure to maintain continuous E&O insurance coverage. On or about April 25th, 2022, the commission received a request to reinstate a license from respondent's affiliate broker. Following this action, the commission administratively opened a complaint against respondent for failure to adequately exercise supervision over the activities of the affiliated broker. Specifically, respondent failed to ensure that the affiliate licensee maintained continuous E&O insurance coverage. In response, on May 26, 2022, as required by 126001-16 2C2, if a principal broker releases an affiliated licensee more than 120 days after suspension, the consent order shall contain a civil penalty of $1,000. Therefore, counsel sent respondent a consent order authorizing a $1,000 civil penalty. So that was sent. Recently, in working to close outstanding cases, counsel contacted respondent related to this matter. Respondent requested this matter be presented to the commission for consideration and submitted the following. To the Real Estate Commission, this response is in reference to the application of a $1,000 for violation of the rules. Factual background. I'm the managing broker and have been since January 2021. The facts of this matter predate my employment with the firm, and I can only rely on the facts as documented in the employee file of the agent in question. On January 14th, 2020, the agent was broker released by the previous broker, and the form was sent to TREC and the local board. It appears the form was faxed, which was the preferred method of previous broker. The agent was removed from the local board's roster and lost access to MLS, as well as being terminated from the company. In June 2020, I received written notice from the commission that a fine would be imposed.
In June 2022. Is that right?
Yes, that's correct.
Since we're reading it in, I just want it to be
Yes,
accurate.
thank you so much. I appreciate you.
My pleasure.
From the commission that a fine would be imposed under the statute. The broker release form that was signed by the previous broker was immediately sent to the commission as proof that the agent had been released from the firm. No other communication was received from the commission as to the status of the fine or resolution of this matter. 17 months later, on November 7th, 2023, I was contacted again by the commission that a fine would be imposed because the original form was never received. Response. It is my position that the facts of this matter predate my duties and responsibilities as managing broker, and to impose a fine for the actions of the previous broker some 46 months later would place an undue financial burden upon me and/or the firm. Furthermore, the issue of my supervisory responsibility over this agent is a non-issue, as he/she was not an active agent at my firm, nor a member of the local board at the time my employment began. The information gained from review of his file leads me to conclude his release was processed in a manner consistent with practices and procedures allowed under 1260-02-021. This matter progressed for nearly 2.5 years before it was brought to my attention in June 2022. My office conducts routine E&O audits, and the agent in question did not appear on our audit. It has been another 17 months since receiving the first notice until now. This matter has been ongoing for nearly 4 years. During that time, neither I nor my previous broker, through review of the file, appear to have been given the opportunity to clear this matter before a penalty was imposed. In conclusion, I restate my position that I should not be penalized for a matter that has taken this long to investigate and for an agent that I never exercised supervisory responsibility over. I respectfully ask that you review the facts stated and dismiss the complaint and fine. The commission, this is back to council. The commission did not receive a copy of the Trek Form 1 submitted on January 14th, 2020. 1260-02-.21 also states the principal broker's supervisory responsibility for future acts of the licensee terminate upon the commission's receipt of the release form or online submission. Therefore, as the commission did not receive the Trek Form 1, the supervisory responsibilities did not terminate. The commission does not regulate the MLS, nor has access to or keeps track of the records related to local board rosters and records. Respondent was added as principal broker on January 15th, 2021, and received the statutory required mailed notifications on or about January 29th, 2021, that the affiliate broker's license was suspended due to lapsed E&O insurance. Therefore, respondent was provided notice the affiliate broker's affiliation with respondent's firm. Any audit of respondent's firm with the commission from January 14th, 2020 through the dissemination of the consent order would have shown the affiliate broker's affiliation with respondent's firm. So my recommendation is to discuss. The statute allows the commission to either assess the same amount of civil penalty, or you also have the discretion to lower it or assess any other form of the of discipline related to E&O, which is why the matter was brought back to you. So those are the issues, the circumstances we have here. Does anyone have any questions?
So the respondent was unable to provide like a transaction record for the fax that it was sent and received by Trek?
No, we didn't have any information. They gave me a copy of the Trek form, but we don't have that in our records.
So this respondent has a hard copy or a copy of the Trek Form 1 that was sent in January of 2020?
Correct.
So, okay.
And the dates on it correspond, the contemporaneous?
Dates on it match with the other individual, but we don't have a copy of that document.
And it only becomes valid once Trek receives it and verifies it?
Yes, that's what the rule states.
That's what the rule states.
And they faxed it, but they never verified that it got here.
That's apparently what they stated. The previous broker, the understanding is the previous broker is the individual that sent in the form in 2020 and did not confirm with us that it was received. So they were under the impression that the individual had been broker released this time, the entire time.
So even though this new principal broker came on board, the fee for the lapsed E&O insurance still applies.
Yes, because the individual was suspended on January of 2021, and they became the principal broker they became the principal broker during the time they were the principal broker at the time of the suspension.
And you don't have a Trek 1 for this licensee landing someplace else?
No, they were with the firm until they were officially broker released, which was well after the consent order was sent.
So in 2020, Trek 1 was sent. The licensee got off the lost access MLS, was not a member of the local board. but yet they were still working and then got suspended. Their license was suspended.
Don't know if they were still working for the firm. I don't have any of that information. But I know like the firm, they had sent them like a notice of termination, everything. But so we just didn't have that information at the time. But I do know that during this time period that individual had renewed their license, and it was with this firm.
I see. So the commission suspended the license in 2021 due to failure to maintain E&O. They never renewed it during the grace period or anything like that.
So their license didn't expire until I'm not sure when the affiliate's license expired really, but the suspension has nothing to do with the license, like the license expiration. That time period, those are kind of separate and apart. The suspension comes from the lapse in E&O. So my understanding is they weren't on the firm's E&O policy is because they didn't think they were still with the firm.
But Trek, there's no Trek 1 for this licensee in question landing at another firm. Okay.
So same firm, different broker. This agent or this licensee, this individual comes to reinstate their license with the new broker. And that's when this is discovered?
Yes, they attempted to move their license out of the suspended status from E&O, which is one of the ways that these complaints are triggered. Otherwise, we'd have like thousands and thousands of consent orders going. So it has to be like a positive move either from the principal broker or the affiliate broker on their part. Either the principal broker releases that individual, or the affiliate broker tries to pay their fee or something of the sort. So they try to reinstate their license from the suspended status.
And this might be a question for Ms. Baker. If we can reach back into past processes, how would a faxed Trek 1 form be processed?
That is a fabulous question. I would have to look into that. Predates my employment.
Right.
I know the team was on, they were AWS at the time, meaning they were working from home. So the likelihood of us receiving that via fax, I believe would be low.
But if we received it on January 14th, 2020 via fax, and that's when it came through, then
Still
that
be
would be
after
the date of the effective date of when they were released from the firm.
And actually in January of 2020, correct?
Right.
The team was still working in the office here.
Yeah.
So I now changed what I said. The likelihood of them receiving it would be great because everyone was still working in the building every day in January of 2020.
2 days in, 3 days out. So
there was someone here.
Somewhere here.
Let me have the timeline squared away.
Okay.
So they were broker released January 14th, 2020, according to this person.
Correct.
The new broker came on January something 2021. So over a year later, the new broker came on. And then the new broker receives this penalty for someone who they thought was broker release a year before they came.
Did the new broker just ignore the notice? Did they communicate with Trek at all, saying, "Hey, who is this guy? He's not with our firm"?
So, like, I checked, and we send out, like, there's statutorily required letters that are to go. One goes to the principal broker at the office. One goes to the affiliate at the office and the affiliate's home address. And the principal broker had a letter sent to them at their firm with this affiliate's information, the new broker, about this individual, January 29th, 2021, and I put that here. So they were put on notice that this person was still affiliated with their firm.
Right. So did that prompt them to contact Trek at all and say, this person's not with our firm? So they ignored it, essentially.
Right. I'm sure what we receive very oftentimes when it comes to this is that no one receives the letters that we email.
That you mail.
But we do yes, that we mail them.
Yeah. Yeah, I that was my note. You're a managing broker. You have a lot of irons in the fire. You have a lot of mail. You have a lot of this and that. Probably got there. Should have responded.
I will say that the mail that we do send out, it says Tennessee Real Estate Commission. So
It's very prominent.
yeah, I would hope that principal brokers
It is
open
conspicuous.
up, licenses that
Yeah.
we send, mail
So, no-
that we send them, because when we send something, it's not frivolous. It's
Oh, yeah.
it's important
Right.
and it's from the commission.
No return to sender, none of that.
My question is, why would this civil penalty not stick with the affiliate, with the principal broker who was the principal broker when the person was still under their employ?
Hold on 1 second. I want to.
And I can correct again. The timeline states that this new broker received the notice of or was sent the notice of violation about this lapse in EO insurance and about the penalty to them directly with their name.
So this principal broker became principal broker of this firm on 1/15/2021.
We have a record of that.
Yes. So it's like she was the reason I brought this before you is because it's like very messy. So 1/15/2021, and suspensions ran 1/29/2021. So at that time of the suspension, she was the broker for
Of
the
record.
individual.
Of
But she didn't think that because she thought that the broker release form had been sent in a year pre.
Right, but she received the notice and ignored it. Saying
She
"You're
probably
on
didn't
the-
recognize the name of the agent. And just
Yeah, probably
go
not.
with it.
Yeah.
But Trek is saying I have a fee on my head for something that I didn't do. You think a phone call at the least?
Right. That's my point. I think they failed to
Don't just
raise their
ignore it.
hand to say, "Hey, let's clear this up."
It's like ignoring a subpoena.
If they called in January, if the newer broker had called in January of 21,
So the way that we run civil penalties and fees for individuals, you have from January 29th until civil penalties and fees for affiliates and brokers don't start to accrue until March. So you have all of February and a couple of days in March to rectify the suspension without incurring any monetary fines or civil penalties.
I'm sorry. Our original ruling was to assess $1,000, or that you assessed $1,000 civil penalty on
Yes,
this broker.
because nothing occurred until 2022.
Any motion would either be to sustain the penalty or to dismiss it.
Have the
Or
full gambit.
the full gambit.
I just don't feel comfortable penalizing unrelated to what happened only because they missed responding. Like $1,000 civil penalty seems harsh for someone who possibly thought it was a mistake. And granted, they should have called, but if that were me, I would think that's egregious. I wasn't even the broker at the time. I would have made sure they had their E&O insurance. They probably thought it was a mistake. So that's just me thinking out loud.
I see your point.
So after that time period, is there any other contact? Is that when the $1,000 civil penalty went out, or is that what kind of contact was made after March of 2020?
So we send the letters are sent on or around 29th. Actually, they're like a couple of days, like in the February time period, and then that's all that's required. But notices are sent out beforehand. Like you've heard us talk about it. We start talking like if you're on the state insurance policy, Rice starts sending out information in October, but we start sending out my Emma information the year before. All of those things go out before. After the letter, we're not sending information necessarily to individuals, but after the 30-day time period where fees and civil penalties are not accruing, you have from day 31 to day 120, there's a time period where the amount is either $200 or $400, depending on whether the individual backdates their policy or they don't backdate their policy. And that applies to the broker and the affiliate broker. Past day 121, that's where you have a separation. After 121, the amount goes up monthly for the affiliate broker by $100, and for the brokers post 121, it's $1,000 flat. And after a year, the affiliate broker's license is revoked, or the broker's license is revoked, depending on whoever is suspended at that time. But if you're principal broker, it is $1,000, and that amount is assessed to you statutorily because you have the requirement to ensure that your licensee has E&O insurance. So, I mean, I do understand it. The issue is here that they were only the principal broker for like 2 weeks in this time period. So if there is grace to be, this would be the time period for grace to be extended, which is one of the reasons I can bring it to you is I don't have that discretion to just outright close something when it's brought to you on my own.
I have another question. The new broker,
yes,
had no reason to believe that agent hadn't been broker released. If they have the copy of their form, so they have the copy of the form. Mm-hmm. So she has no idea whether Trek actually received it or not. And I don't know how big the firm is, so how many people are they managing? I have no idea. But if the previous principal broker says, hey, they were broker released on this date, here's our form, what obligation does the new principal broker have to double check and follow up on all of those things? I just don't see any fault with this new principal broker whatsoever.
It goes to the mistake of when you're receiving these notices, you're like, look, according to our records, this broker wasn't a part of our firm. Why are you sending us this fee?
They were sent a letter from the commission in January of 21, 2 weeks after they became managing broker, and they're saying they didn't get that letter.
What if can you do a letter of warning for failure to respond, or does that have to have a civil penalty?
No, you can do whatever, but I would just like to chime in real quickly on something. I would call this willful ignorance, because there are several tools in your toolbox to check to see who's on your roster. You can request your roster at the commission at like any time, and this individual's name was on there from January 2020 until now. And so that's why I stated they did E&O audits internally, but if they had requested at the commission, they could have seen that the individual was still on their firm roster's information.
Do other firms do audit? When they do audits, they look at their records and look at Trek's records?
We get public records requests weekly for individuals asking for rosters for their firms.
That's how firms maintain the.
In some of them, it's because of this E&O issue, because they don't want it to happen again when they've had individuals that have been stragglers that they didn't know about beforehand.
it's really a checks and balances system. You also need to check with your MLS and hopefully you check with Trek as well.
Right.
I
So
will say the individual that lacked E&O insurance, that wasn't his first time lacking E&O insurance.
I'll say this. I'll reach back into my memory of pre-online services. And if I remember, government agencies, when they receive documents that they have to maintain records for, they receive it and they have a timestamp clock where they timestamp it so that they can say it was received by this date and this time. And then there's some other process after that in terms of preserving that file. So
Also,
is that something similar at the state of Tennessee, I would imagine?
Yes, and we've taken it since I've started here. We've taken it a step further. Whenever we receive mail back that's sent back to us, we now notate that within the system that on this date, this was sent back to us.
Return to sender.
Return to sender, or
Okay.
what have you. Just so when situations like this arise, we can say we tried to send XYZ out. You did not update and maintain your information in core, which is required, and it was returned to us. But we did make a good faith effort to do so.
And let me ask you this. Is there other documents not related to this, but just that have been put into this firm's file or this particular broker's file that you have received successfully and date stamped? And
We received the subsequent principal broker, the Trek 401 to broker release this individual since then. That was done electronically because why are we faxing in 2020? I don't know.
well,
but
again, it was the preferred method of the previous, broker.
right, of the previous individual, but like we do like receive them, and I mean, but that's just kind of like where we are.
I will say this principal broker that's in question has submitted properly the proper forms online. I don't even know where the fax machine is in this building. So
All right, let's get a motion.
Make a motion.
Yeah, you can make a motion.
I'll make a motion to dismiss and see how it goes.
Okay. I have a motion. Is there a second?
Second.
I have a motion to dismiss this case made by Commissioner Torbett, seconded by Commissioner Tucker. Is there any further discussion? Please, God, no. Here we go. Commissioner Gwynn, go ahead.
So, Anna, when a Trek form is received by Trek 1, is it automatically approved? In other words, there's no sign off or anything like that by us? Or is it just assumed that when the commission receives a Trek 1, it's a done deal? Or
correct. When
Okay.
it's now submitted electronically, we put it into our online system. It's called Core, and we maintain those types of forms in that system.
There's no system that says when you're doing a Trek 1,
We don't confirm, I think is what you're asking.
well, that you send out the person that receives the agent is, oh, by the way, there's an outstanding invoice or an outstanding fine. Before you get this person, do you know that there's $1,000 outstanding? See what I'm saying? Or is that, am I off somewhere?
I don't think, one moment. I think that's a little different because that's an individual license.
So like for this particular, like this person, if they were to like, if you have like an outstanding civil penalty, and it's still open, like something that's still open,
Yes.
you can renew your license and move forward. But if something, because we're still working on it, right? But if something's outstanding, sent, like for example, if it's sent to collections and you haven't paid on it, you have to satisfy that amount before your license can move forward to another location. Like if it's been flagged or something of the sort, like you can't just like move freely that way.
You can't ask before you release a broker to B, let's call it, or number 2, you pay the $1,000 and I'll let this person go. You can't do that, right?
I don't think I'm following your question. Will you repeat your question?
So I'm just trying to understand if the $1,000, I mean, it's always been out there. Correct.
This person, it's been pending for a
Pending.
while.
Yes.
Yes, right.
Pending. So
No, so like just because it's pending, we would still if they want it to be released,
you would say
we
fine.
would still release their license,
Okay.
right? Yes.
All right.
We can't.
So it's not like the person releasing can look and see. Well, they can look and see there's a fine.
Like the
It's always been there.
like if a prospective broker wanted to see if an individual had like an open case or something, they would need to like and either inquire with the agent and ask if they have open, discipline, or submit a public records request or something of the sort to find that information out. But if you have like outstanding discipline, that would be, we would release them. A lot of brokers, once they find out that an individual has this E&O issue, they broker release a lot of people. A lot of individuals get broker released during the E&O cycle if they haven't renewed it. So that's a mechanism, a tool that they do have, because they will ask us like, "Hey, I didn't know this person was still was still on my record. And what should I have done?" And I was like, "Broker release them."
A broker release doesn't need a consenting signature. Just
By the licensee, and they can just release. And just out of curiosity, is this a multi-office firm?
Yes.
Thank you.
Yes.
All right. Any other questions or discussion? Hearing none, I'll restate the motion. The motion is to dismiss.
We have a second.
We do have a second. Let's go ahead and vote. All those in favor of the motion to dismiss, say aye.
Aye.
Anyone opposed? By my count, that is a 7. That motion passes 7-1, with Commissioner Gwen voting no. All right. Thank you very much, Council, for bearing with us. We'll go ahead and move on to commission discussion. We're actually we had a little time for it. I just want to bring up the April relevant meeting again that was noted earlier. 2 commissioners are available to go. It's April 16th to the 18th. Check your calendars, and if you're able to attend, please let Ms. Baker know so they can include you on the arrangements. Any other commissioners have anything to state?
I have a question.
Go ahead.
I received a call from an agent, and they were concerned because their education is not all showing up on one of the sites. It's not all moving over to CE Broker. So that particular agent was having a hard time distinguishing exactly how many more hours they needed or if they had completed.
I would hope that, goodness, I don't know what's the problem today. I apologize. I would hope that broker would call our office, and so we can help them work through whatever issues they may be having with CE Broker.
But should all of the education move automatically over?
There are instances where something doesn't transfer properly, and we may have to do it manually, but that's the exception and not the norm.
But most everyone should have all their education moving straight
Correct.
over to CE Broker.
Yes, that is correct. There are exceptions, but they're very few and far between.
I would state that my education has all moved over to CE Broker quite succinctly.
Good job.
Good job to CE Broker, but
I do have one note. The next commission meeting will be Wednesday, January 10th, and we will most likely have a hearing the following day on the 11th. We are 90. What did I say?
Sorry, we will likely have a hearing that begins that day and runs on the 11th. So it'll probably be a 2-day hearing.
Thanks. Thank you.
the normal meeting for January will be the 10th,
Correct.
and a formal hearing will begin that day
Yes.
to be concluded likely on the 11th.
Correct.
Okay.
If it doesn't finish on the 11th, it carries over to like another month.
February.
We don't run to another day. Like we don't go to the 12th.
And we
How
don't have,
long do we go on the 10th? Like, can we finish it on the 10th?
On the 10th, if we finish it on the 10th,
We
How
could.
late can we stay on the 10th? Like, till like 5, 4?
it would be like probably 5 or 4.
Judge says we've done enough for the day.
Yes.
Yeah, I've had judges that have said, I'll stay until you're done. So it just depends. Up to you all and the judge that day.
It depends on like how the hearing progresses that day. Like if we think we can get done, but like schedule wise, the hearing is scheduled to begin at 1 on the 10th.
Oh, then I guess that means the box lunches during that day.
I will make arrangements for that.
Okay, good.
could it begin sooner than 1? Just out of curiosity.
It depends on what was on the agenda for January. We have
Judge,
Probably the judge and
the judge is going to show up at 1.
We also have to publish.
That's right. Yeah.
We have to have a set.
Right. So if we're done with normal business at 11, there's 2 hours there that,
Go to lunch.
great. That's good. That's, I had a nap planned on January 10th.
We do business.
And just to, we will learn about the contents of that formal hearing on the 10th. Okay. Thank you.
There a motion to adjourn? You got a motion to adjourn, seconded? Good. Motion to adjourn by Commissioner Smith, seconded by Commissioner Moffitt. If there's no objection, we are adjourned.
Thank you.
Thank you.